How do you prove, what is the evidence that a court would be needing to agree that this person actually was under allegiance to a foreign power by their own act at the time? What do you bring to the court? You catch a drug dealer, you have to bring the drugs in. You have to,
in this a case like this will turn on possession of the passport, because it has been established, and we reference the Jamaica case of Dabdub versus Vaz. It has been established that the possession, utilization, renewal of a foreign passport all represent acts of allegiance to that foreign power whose passport you hold.
So ownership and presentation of that passport becomes important.
Yeah, very important, critical, critical. Now, in this matter, both Mr. Senja and Mr. Skerritt presented that they got citizenship through their parents, which would mean that that was involuntary. They were not the ones who volunteered to go and get citizenship. When they were infants, they got it through their parents. And the court is not going to disqualify you for that.
Okay.
The court will disqualify you if, as an adult, you're in possession of the passport, which is an act of allegiance to the foreign power state.
Because you would have been expected to determine as an adult whether you wanted to continue to have this or give it up.
Right. So now, we know what the qualifying criteria is. We know that the complaint is that they have offended the qualifying criteria. And so the question now becomes, how is this matter going to be dealt with in the court?
Exactly. Because you will hear people ask, but if it is the passport that's the determining piece of information, how can it be that there was apparently a ruling prior to the actual hearing of the case that the passport would not be allowed to be presented? That seems kind of incongruous to the average non-legal person.
The matter is filed in the court, and when the matter is filed, along with other complaints against the respondents' lawyers apply for the petitions to be struck out, and so that matter is heard in front of Justice Errol Thomas.
And that was when again?
In August of 2010, we got the ruling of Justice Errol Thomas, who threw out the bribery petitions, the treating, the abuse of DBS radio, etc., and he made a determination that the petitions would proceed to trial on the sole issue of disqualification for nomination and election. Let's take the case of Mr. Skerritt. At paragraph 173, Justice Thomas said, in the case of Roosevelt Skerritt, the fact of citizenship is not denied, having been acquired in his infancy. However, the matter of the passport is rejected in the application filed on March 30th, 2010. That is the application to strike out the petitions.
Okay, and this was moved by Mr. Skerritt's lawyers to get it out of the way so there would in fact be no case.
Yeah, right. Yeah. However, in Annex C to the said application, that's the application to strike out, there are documents attached to that application to strike out. Annex C to the said application is a letter to the electors of VCAS dated the 17th of December 2009. And in that letter, according to Justice Thomas, the matter of, quote, my possession of a foreign passport, end of quote, is raised. But nothing more is said except that, despite what, quote, despite what you have heard, I am validly nominated and your votes for me will not be thrown away. The view of Justice Thomas was, if you're claiming you're in possession of a foreign passport and at the same time you're claiming you're validly nominated, I think there's an issue here for trial. Because if you're in possession of a foreign passport,
as an adult,
on the face of it, you cannot really be qualified. You can't really be validly nominated. And so he ruled that the matters will go to trial on the issue of disqualification for nomination election.
Okay.
Good. Now, when it came to the trial, this letter of the VCAS constituency, Mr. Skerritt's letter to the VCAS constituency came up, where he said, it has been brought to my attention that there are allegations circulating in some local media and among certain people that by virtue of my dual citizenship and my possession of a foreign passport, I am not qualified to be elected as a member of parliament for the Vacas constituency, and as a result, any votes cast for me in the December 18th election shall be thrown away. Remember how Justice Thomas read this. When Justice Thomas saw my possession of a foreign passport in the same sentence with my dual citizenship, which Mr. Skerritt has not denied, he didn't see this as an allegation from other people that was being reported. He saw Mr. Skerritt stating the fact of his status, which status people were indicating would cause him to be disqualified, but he was assuring them that that was not the case.
Okay.
Remember, Mr. Skerritt did not defend himself. And so, because he did not defend himself, he said nothing to these matters. His lawyer, of course, had an interpretation of it. But the learned trial judge now, the learned judge, had an interpretation of this statement by Mr. Skerritt.
Before you proceed, let's just sum up so that the viewers can follow carefully. What you're saying is that the issue of Skerritt's possession of a passport
is what the court has to decide.
Is what the court has to decide as a disqualifying factor or not disqualifying factor.
The passport would disqualify him.
So the passport then becomes central.
Critical evidence, which is why I'm going slowly on this matter, which is considered circumstantial evidence of his possession of a passport.
Okay.
And
you're saying
this circumstantial evidence of his possession of a passport is picked up by Justice Thomas, and it is on that platform that he sends the matter forward to trial.
To hearing, okay, to trial.
The judge Gertel Tom now takes issue with this because, of course, she is ruling that Mr. Skerritt was qualified. She cannot rule that he was qualified if she found evidence that he had a passport. So she has to get rid of all the evidence. She has to deal with the evidence and direct and indirect.
That's what bothers a lot of people.
Good. So now she says, she goes now into an interpretation of Mr. Skerritt's statement, my dual citizenship and or my possession of a foreign passport. And he says, when the letter is read carefully, it shows that in the first paragraph, Mr. Skerritt outlines what were the allegations made against him in the media and by certain persons, that he is not qualified to be elected because he has dual citizenship and or because he is the holder of a French passport. She's claiming now that Mr. Skerritt never admitted he's a dual citizen. He never admitted he has a French passport. But Mr. Skerritt has admitted that he's a dual citizen of France since 1972.
Well,
so how could that now, how could a judge in a situation where Mr. Skerritt was not required to testify, where he could not face any questions about this, how could she now come back, turn it around, where a judge before her has seen it as an admission that he has a passport? She turns it around to say, no, it's not an admission. He is stating allegations that people made about him. Okay. He is not.
Let me ask you about something related. Wasn't there something to do with some letter written by Mr. Skerritt to the French authorities seeking to get a passport revoked or?
Well, no. Listen to this. This is the.
And so, wouldn't that be another kind of admission of having a passport?
This is admission number one that we've just dealt with, the letter of the 17th.
All right.
And where Mr. Skerritt appeared to have admitted, the judge came back in a situation where he did not defend himself. The judge came back to defend Mr. Skerritt.
Okay.
With her arguments. In fact, where Mr. Skerritt said what he meant, the judge turned around to give you something that meant what Mr. Skerritt said.
Okay. She interpreted what he said in her in another way.
Good.
Okay.
The letter of the 27th of November.
Yeah. We have about a minute before the next break.
There's one from Mr. Skerritt and there was one from Mr. Saint-Jean, both of which Mr. Senja's letter was a couple of days later. Mr. Skerritt was on the 27th, but both of them had this identical paragraph. They're asking for immediate renunciation of French citizenship, and they're saying a recent decision in Jamaica raised some new questions about dual citizenship, and I would therefore not want to cause myself to be disqualified to contest the 2009 elections in my country.
Okay.
This is significant, Afi, because once the judge agrees that the recent decision in Jamaica is a reference to the case of Vaz versus Dabdoob, Dabdoob versus Vaz.
Okay.
And in that case, Vaz was disqualified, not because he was a dual citizen or because he had U.S. citizenship, which he got through his mother. He was disqualified from sitting in the parliament because he was in possession of and traveled on a U.S. passport. Now, this is seen as an admission that they have passports of France because they both know that they're not going to be disqualified if, like Vaz, all they have is citizenship through their parents. So in referencing Jamaica as a potential, and not wanting to cause myself to be disqualified to contest the 2009 general elections, it has to be the disqualifying vice relative to Jamaica that they're concerned about.
Okay.
And that disqualifying vice relative to Jamaica is the use of a passport.
Okay.
The arguments in court from Mr. Senja's lawyer, for example, was that, oh, the letter was written by Mr. Senja, it was not written by a lawyer, and so it could not be held against him if there was any legal thing in there that he didn't understand or that had implications and so on.
Okay.
Paragraph 30 of the judgment is very interesting, the ruling.
That's
It says,
the current ruling.
it says, the letter was signed by Mr. Senja. There is no evidence which shows that the letter was prepared by an attorney or on the advice of attorney. Mr. Senja seeks to renounce his French citizenship on the basis that his dual citizenship may cause him to be disqualified in the view of the decision of the Jamaica court. I bear in mind that it is not disputed that Mr. Senja's French citizenship is by affiliation. Mr. Green's pleaded case is that Mr. Senja obtained a French passport between 2000 and 2002 or thereabout. And then the judge goes on to say, there is nothing in the letter on which an inference could be drawn that Mr. Senja admitted he had obtained a French passport.
Were you seeking to get it
Between
rescinded?
2000 and 2002, or thereabout, or for that matter, at any time. This effectively, in my view, Athi, is the judge arguing or making a case for somebody who came before her court and refused to testify.
What's the significance of this ruling, Lennox, and what are the implications?
Well, before I get to the significance on the ruling, you were talking about some other issues there have in regard to, with the caller, you were talking about the disclosure matter. The lawyers for the petitioners did make a request to the court for disclosure of the passports of Mr. Skerritt and Mr. Senja. And the arguments used was that you cannot compel witnesses to bring evidence that would prove the other side's case. Now, whenever that comes up, I ask people to bear in mind what we're dealing with. This is not a murder trial. This is not a trial for robbery. This is an inquiry into whether a member of our parliament, the highest decision-making body in the country, was validly elected. You want to tell me that people want to protect an individual's right to trick, deceive, to remain silent, so that he or she could remain in the parliament if they did not meet the qualifying criteria?